Yes, Your Honor, I can.
Right, we'll go on the record in People versus Phillips. This is file number 25543. The record should reflect Mr. Phillips is present here in the courtroom today. If I could have both counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Phillips.
Okay, Mr. Trush, did you have a chance to go through the pre-sentence report with Mr. Phillips?
I have, Your Honor.
Mr. Phillips, did you have an adequate opportunity to go through that report and talk to Mr. Trush about it? All right, Mr. Trush, I know that we have some challenges to the scoring. We'll address that in just a second. I did also receive communication from the Lions Den. I had a chance to review that, just so that you're all aware of that. Mr. Trush, I also received a letter from Russell Anhilami in regards to Mr. Phillips. I also received a letter from, I believe, your daughter, Ms. Chilniak. Yes. Okay, I had a chance to review that. As well as from your father, Gary? Yes. So I did receive all of those ahead of the hearing today, and I had a chance to read all of those. Mr. Trush, before we get to the scoring challenges, are there any other additions, deletions, or corrections to the CSI?
No, Your Honor.
And then in terms of your challenge to the scoring of OB 15, is there anything you wanted to say to the record on that?
Just to highlight here, Your Honor, I mean, this is a somewhat unique, I think, a unique scoring in the sense that we don't have this charged as a delivery type offense. I don't think there's any objective criteria to point to. We're not talking about a controlled buy. We're not talking about individual packaging, scales, buy money. I mean, we're really not talking about any of the objective criteria that we normally are looking at when we look at that type of thing. I mean, really what we're basing this on is purely the amount of, the amount of the substance that was found. And I don't know that we can get to a preponderance of the evidence based on that. I think that we start to get into the question of we're asking now, how much is he using on a daily basis? We're getting into the question of, how long was this supply intended to last? I just don't think that we can get to a preponderance of the evidence based on that criteria. I don't think the scoring of OB 15 is appropriate.
All right, just vote.
Yeah, this is a significant amount of methamphetamines, but what I would point to is Mr. Phillips' circumstance at the time and the cost of buying that and the way to finance it. He was living in commercial placement. He spent most of his life in and out of jail. I don't know when he had been released from prison, but it had been fairly recently. I mean, we have his employment history and his living expenses. So for someone to have this much methamphetamine for personal use and be able to afford it's not at all practical. I mean, this isn't like talking to a jury where juries might believe that somebody had this much meth on hand for personal use. It's clear from the amount of methamphetamine that it was a significant cost to him. And the only way he really had to finance his situation was to sell this methamphetamine. So the standard's low and I defer to the court, but this is a lot of meth. Thank you.
All right, Mr. Trush, any response to that?
I mean, I guess I would just indicate, to me, I mean, the best indicator here of, the lack of preponderance of the evidence, I mean, the standards aren't exactly the same, but I mean, this wasn't charged as a delivery. If there was probable cause to believe that this was possession with intent to deliver, I mean, it wasn't charged in that manner. I mean, I think that that's tacitly the prosecutor acknowledging that she can't meet the burden to show that it was a delivery amount, that it was possession with intent to deliver. I think that is a very relevant consideration for the court to look at there. Thank you.
All right, so OB 15 involves aggravated controlled substance offenses. It allows for the scoring of 5 points where the offense involved the delivery or possession with the intent to deliver any controlled substance, which we're not dealing with that as a sentencing offense here. We're dealing with possession. Not delivery or intent to deliver. So that leaves us with the second sentence under 5 points, which is or possession of controlled substances having a value or under such circumstances as indicate trafficking. And that's a pretty broad statement and could include lots of different types of conduct. I read the pre-sentence report very carefully here. There's not a whole lot of information. The description of the offenses, maybe a couple of short paragraphs. So there's not a whole lot for the court to go on other than the weight, which was, I believe, 19 grams, which is certainly more than what would be considered a daily use amount. I mean, in and of itself, it's not in the scope of cases that the court sees. It's not, I would say, a strikingly large amount, certainly, again, more than what we would consider for daily use. But the circumstances here, as I read them in the report, is there were a number of individuals at this residence. I think based on other cases that I've had with these individuals, Ms. Leal, Ms. Henning, I've had both of them in my court arising out of this incident, that there was a lot of people there with a lot of drugs there. So I don't know that there's enough information for the court to go on that all 19 grams of those were necessarily Mr. Phillips, or that they were being trafficked. I think it's an equally likely scenario where this was just a whole bunch of meth that a bunch of people had access to and were using, as opposed to a situation where Mr. Phillips was trafficking out of that residence, again, based on the information that I have. So if we're just relying on weight, I don't think it meets the preponderance standard. I think there would have to be other factors there that the court could use to rely on to qualify as circumstances to indicate trafficking. So I really think it's a burden of proof issue. I think there's some evidence certainly that was going on based on weight and value, but I don't think there's enough evidence for the court to conclude that it meets the preponderance standard. So the court will grant the challenge, and the court will score OB 15 at 0 points, which brings us to an OB level of 10, or OB total of 10. Does that change in and of itself? I don't have the grid in front of me. Mr. Trush, does that change the range?
Your Honor, I have the grid in front of me. That would still remain at level 2, at least at this junction.
Okay. So then your second challenge was to OB 19, and Mr. Trush, any oral argument on that?
So, Your Honor, actually, since drafting the challenge and ultimately filing it, I've actually thought about this issue quite a bit, and I think there's two pieces of this puzzle to look at. And the first piece of the puzzle is really sort of what I've outlined in the brief. And again, admittedly, when I wrote this, I didn't think about the other side of it. But the first piece of this is Mr. Phillips, what I'll call post-offense conduct. The post-offense conduct, I don't think supports the scoring here. What we have is Mr. Phillips ultimately informs the police when talking to them that they missed something at the house. He informs them, hey, you missed some drugs there. He tells them where it is, how it's packaged so they can find it. And I think there's no part of that to me that suggests interference with the administration of justice. To me, that suggests the exact opposite. He is being cooperative. And frankly, that's consistent in my experience with Mr. Phillips in regards to this and other matters I've represented him on. represented him on over the years, also just other interactions I've had with him in my prior capacity as a prosecutor over the years. My experience has been that, frankly, once the cat's out of the bag, Mr. Phillips is usually fairly cooperative. He's usually pretty willing to admit what he's done once, he's confronted with it. So I don't think there's anything in the post-offense conduct that would support it. And now the question that I think the court will have to sort of grapple with is, can the pre-offense conduct potentially support the scoring? And that is to say, if the department's position or the prosecutor's position is the simple fact that these drugs were hidden there in the first place represents attempted interference with the administration of justice, I think that's something that the court would have to assess. But I think that it's most likely that that's not what's going on here. And what I mean is, I think it's equally as likely that if this substance, if he hid this substance, if he's in fact the person who hid it, that it's more likely hidden not out of, fear of trying to hide it from the police raid that may or may not occur, but just because it's a substance that has value, and that's often how it's treated. Right. I mean, we know that people often keep controlled substances in lock boxes or, in disguised containers and hidden. Again, I don't know that rises. I think it's clear that the post-offense conduct does not rise to the level of supporting the scoring. I'm not convinced that the pre-offense conduct would support that either. Again, even if the court were to get to the point and find that he's the person who did those things pre-offense.
Thank you, Ms. Coe.
I'm not sure, and I looked at the sentence a couple of times because I didn't get this until I didn't have a chance to review it until yesterday. I got it the day before. But that in the police report, it says that Sergeant Copadlo informed me I had missed some narcotics and they went back and searched it. I don't think that Mr. Phillips was the person that informed them. They forgot that they had missed it. I think he informed another inmate who informed the sheriff. But either way, Mr. Phillips' circumstances at the time is the problem, because he's living in commercial placement and he's subject to parole search. So the question is, why are the narcotics hidden? And they're hidden because it's not like a regular person where they could possibly get a search warrant, somebody could tell on him and they could show up. He is regularly searched in his commercial placement because of his conduct and how he was on probation in a commercial placement. So I think that's why it was scored for 19. Normally somebody probably couldn't be scored in this circumstance, and I certainly wouldn't argue it if it was just a regular person that they got a search warrant for, because people probably don't think about what could happen if somebody gets a search warrant. But he was subject to regular searches in that placement. I think that's why the drugs were hidden. And so I would defer to the court. And I think if the circumstances were just one of my average people, I wouldn't even make any argument at all. And I would agree with Mr. Trush. So thank you.
Yeah, all right. So reading through the report, I mean, the way it's written here is that the defendant revealed to another inmate, and then law enforcement was informed. So, Mr. Trush, I don't know how accurate your factual assertion is that Mr. Phillips was being cooperative or some way wanted to help law enforcement by revealing to them that they missed some substances. Because if it went through another inmate, that kind of torpedoes that argument. And then Mr. Trush, I mean, I don't doubt your assessment of Mr. Phillips and his motivations and the way he's behaved in the past or how he comes across to you. I don't think that's something the court can rely on as an evidentiary basis for either finding or not finding factual support for the scoring of a offense variable. So looking just at the information that I have, there clearly was some additional substances that were there at the time of the search that were revealed later. Mr. Phillips, in my view, at least from a circumstantial evidence standpoint, I think the court can infer that he knew about those substances at the time. He revealed that later. The fact that they were hidden and not revealed at the time, I think does provide a factual basis from hundreds of the evidence standpoint that there was an interference with the administration of justice. So therefore find that OB-19 is properly scored. For that reason, the court will deny that challenge. And so that leaves our scoring again at the previous range, which is 1947. Mr. Church, did you have any additional challenges to the scoring?
No, Your Honor.
Ms. Coke, do the people have any additions?
No,
Do the people have any challenges?
no.
Anything on behalf of people for help?
I always wonder when I see somebody who's, in their fifties and still in these circumstances, at what point they're going to realize that maybe this isn't the lifestyle they want to lead. And certainly Mr. Phillips is not there yet. When you look at his history, which includes multiple convictions for delivery, controlled substance, he's on parole. You look at his lengthy criminal history of 12 felonies and 13 misdemeanors. His PRVs are almost double the highest that they can be. They're 135. And of course, that's because he's got all these high severity deliveries. I don't know why somebody in this circumstance who is, out of prison, subject to MDOC, living in commercial placement, so they gave him housing. He had the chance to make better life decisions and he frankly did not. I think he's earned, the higher end of the guidelines because he doesn't seem to have any interest whatsoever in getting his act together and becoming a productive member of society. Because I think at 53 years old, we're not having the same discussion about people whose brains aren't developed for good decision making. We're talking about a man who's been around for a long time and knows exactly what he's doing. Thank you.
Thank you, Mr. Church.
Thank you, Your Honor. I don't dispute a lot of what the prosecutor says here, and I think honestly, part of what she said is very well taken. You have to ask yourself when we have a person in front of you of Mr. Phillips' age who's still engaged in this conduct, what's going on? And the prosecutor frames this and says, that he, has he decided this isn't the life he wants to live? And I don't quite think it's that simple. I was going through Mr. Phillips' history and I counted more than 15 substance related offenses in his history. And frankly, that wasn't even all of them. And that's not even taking into account the offenses that are substance related, but not on their face, right? We all know that there can be a theft offense that's substance related that on its face doesn't appear that way. I think what this is this is a picture of what addiction looks like. Mr. Phillips has engaged in treatment. He has made efforts to change things. And when I talk to him, and he's sober, he expresses that. He has told me, and again, the court has the information from the Lions Den. He's expressed to me how a long-term program would be good for him because we know that we see people released, and we see people go back to the same patterns, which is to say, I think Mr. Phillips, unfortunately, hasn't quite recognized at this junction that, the saying in recovery, right? You have to change one thing, everything. I think that he goes in with intentions to make changes, but what he does is find himself surrounded by people who are not looking to make the changes, and he finds himself falling into old patterns and old routines, and that happens. Um, the recommendation here is for 36 months, which is the higher end of the guidelines here. I would suggest to the court, I certainly can understand how that recommendation could come about. He has been accepted in and has the opportunity to take advantage of a long-term treatment program in the Lions Den. I would suggest to the court that I think that is a better use of resources than sending him to MDOC. Even if the court imposed a lengthy county jail sentence and allowed him to go into the program following it, I think it makes the community a better place. Uh, the community's interests are served by Mr. Phillips, addressing the substance abuse issue. And I say that not just, he's served by that, but the community is too. Mr. Phillips is a father and a grandfather. And, he's expressed to me how, he wants to be able to be there and be a positive influence for his grandkids, and his daughter. Um, I think that the interests of the community are better served with a lengthy county jail sentence followed by admission into a long-term program. Something like the Lion's Den would be a great program for him. Uh, this is kind of last stops for him. As the prosecutor indicated, his PRV level is devastating. I mean, his PRV level means that, almost any offense he commits, he's going to be at the top end of the grid. Um, I mean, so I would suggest to the court, I think the resources in the community are more well served by recovery as opposed to incarceration. Thank you.
Thank you. Mr. Phillips, anything you wanted to say?
Oh, yes, sir. First of all, I in no way intend to stand here and downplay the severity of my crimes, the impact that the things I've done have had on the community for years. And I take full responsibility for what I've done. And I would like to ask you to allow me to enter into this program with a chance to be around the right people for an extended period of time. The new sense of purpose it would give me, the structure this program would give me, and quite frankly, just the platform it would give me to help other people down the road to use my experiences and my knowledge of drug abuse and the problems it causes in people's lives. Now, I've done a lot of research. I've had my family do a lot of research on this program. It's 8 to 10 months of rigorous Christian-based learning. I just know deep in my heart that this is what is going to help me more than going to prison. My life has been a revolving door, going in and out of prison, coming back, getting on drugs. And I know that it looks crazy. You look at and I must look like a lost cause looking at my history, but I'm not. If you let me go into this program, once I graduate after 8 to 10 months, I can stay on and work for them and become a counselor. And I've been doing so much thinking about that. And that's what I want to dedicate my life to that. And I would be good at it. So I can absolutely be not only a productive member of society, but an asset to the community by doing that. So, and I'm just asking you to please let me try to, go into this program and make the changes I need. Because my lawyer, right, I get out and I'm surrounded by the wrong people and I have the best intentions. I've tried so many times. It's been since I was 15 years old, I've been on drugs. And I don't want that anymore. I want to change my life. And I don't see me going back to prison changing anything. I'll get right back out. It'll be the same exact spot I was in every time. But this program can change my life. And I've always known God has been there. I've just never known how to get past the barriers, the drugs, and the problems they cause in my life keep me from that, So I've done a lot of praying on this, and I hope you can see the sincerity and you give me this chance, because I will make the changes, and this program is the answer. I know it is. It's what I need.
Okay. Mr. Phillips, as I indicated, I read through all the letters that were submitted and the information about the Lion's Den, although I'm familiar with that program already. I read through the pre-sentence report, so I'm familiar with the circumstances, what happened here, pre-sentence information in that report. I'm also familiar with your background and your history, again, based on the information in that report. And, I was certainly struck by the letters to your daughter.
Matter of fact, not to cut you off, I'm sorry, but my daughter went through your drug court program with you and changed her life. Really proud of her. She's got big support right now.
I certainly understand your circumstances and where you're at now and how you got to this point. And, I don't ever say that anybody's a lost cause. I think anybody at any point has the ability to reform themselves, to get the kind of help that they need to address their substance use disorder and the reasons behind that. Usually there's a lot to unpack underneath that. It's not just substance use, that's a patient, other issues that it's covering up. So I don't ever think that anybody's a lost cause or that they don't have the ability to get help and move forward. There's some aggravating factors in your case, as we've all indicated. Your past history leaves you in a situation where you're getting prison recommendations and prison guidelines. The guidelines in this case are 19 to 47. So for the court to sentence you below that, which I would have to do in order to be able to attend the Lions Den or any other program, or would have to have substantial and compelling reasons to go below what the current guidelines are. And I believe that you're sincere in your desire to move on from this point, but there isn't anything else other than what you're saying here in court today in your past behavior and the circumstances that bring you before the court on this charge to indicate that you're going to or would follow through with that. And maybe this would be the one time that you did. But in order for me to go below those guidelines, again, I have to find some kind of substantial and compelling reason to do that. There just isn't one here other than you saying that it's going to be different this time. And it's hard for me to have confidence in my scheme looking at what I'm looking at to think that this is going to be the time. I think to the extent that once your sentence is served in this case, there's no reason why you have to wait until you're charged with another crime to seek out a program like the Lions Den. There's no reason why when you're released on parole, you couldn't have done that this past time or couldn't do it again in the future. There's no reason why you have to wait for a court to order that or to give you the opportunity for that. You're going to have opportunities to do that. And if you're really serious about it, and that's really the change that you want to make, then I hope that you do that. But at this point, again, your past record is what it is. And they're just, the fact that you're on parole when this happened, there's just really no indication that things would be different this time. Certainly not enough for me to go below the guidelines and the legal standard that I would have to do that. I do think that a sentence within the middle of the guidelines is a reasonable sentence. I think it accounts for your past record or what happened in this circumstance, the fact that you were on parole when this occurred. And so that is the sentence that the court is going to impose, 36 months. The Michigan Department of Corrections to 15 years. Because again, of your parole status, you have credit for 0 days served. The court is going to order a crime victim exception of $130, court costs of $325, state costs. You have the ability to go up the sentence. Mr. Thompson can help Mr. Phillips with his appellate rights. Mr. Phillips, we're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court appointed attorney. Help you with any appeal.
This is Mr. George Phillips, John.
Yes.
Sir, you're gonna date an initial here that indicates you've received them. It's not the same as filing an appeal, but it tells you your time limits for filing appeals for 14 days. 36. 2 sheets that you're gonna keep are the forms you file with mailing. To start that appeal process, you can both request a court appointed attorney and preserve your right to appeal. So I'm gonna take these top 2.
Just this as a housekeeping matter, he's still on this bond revocation warrant. You could please sign.
flexibility.
Will I have a chance to see Mr. Truce before anything happens, before I was leaving, or?
Mr. Truce, can you get in contact with Mr. Phillips at some point today?
It is my intentions this afternoon to try to get over to the Crawford County Jail. However, I did want to ask the court, to the extent the court has the authority or ability to do so, is it possible to have Mr. Phillips stay in the county jail um, for the next 30 days? He still has a matter in Otsego County that we have to resolve. It's currently scheduled. We were trying to get it today, but it's just not going to happen. It's currently scheduled for May 5th, or May. It's been a week, Judge. March 5th. So to the extent possible, can we have him remain in the county jail as opposed to going to MDOC?
I don't have an objection to that, but that's not something I think I can order the jail to do or not do. So I certainly don't have an objection to that, but I think that's something you have to work out with the jail.
And transport set up by MDOC, they likely have already got the recommendation and worked on transport. So the jail sets that up. Just so the court's aware.
Ma'am, can you tell me your name, please?
Ms. Misick, Your Honor.
Leah Misick?
Yes,
We'll go on the record in People versus.
I can't really see. There it goes.
So you can see us now, Ms. Misick?
Yes, I can.
Okay. Yeah, I have the file here, if that's helpful.
I'll just put it in. Later. All right, I believe this is a probation violation arraignment today, is that correct?
It is, Your Honor. Ms. Misick had a hearing Monday. She advised she had been experiencing homelessness and had not received the court notice. So she didn't appear for that hearing on Monday. Okay.
Have you had a chance to go through the violation with Ms. Misick?
I did, Your Honor. I believe she wanted a hearing on this. She has an explanation for what, from her perspective, was occurring.
All right, Mr. McFalder, do we want to go ahead and set this for a hearing?
Judge, I know Judge Hunter asked us to do this as a contempt warrant rather than a violation, so I guess I'm not sure how to proceed on this.
All right, so I'm just going to enter a not guilty plea on this Misick's behalf today. The court will set this for a violation hearing or contempt hearing for her failure to appear. In terms of bond pending that hearing, Mr. McFalder, do you have any input on that?
Well, Judge, she has a pending violation for failing to report to her supervising agent. She's being supervised out of county. And then she failed to appear for court on Monday. So, I mean, I do think some bond is appropriate, Judge.
Your Honor, I understand what Mr. McFall is saying, and obviously the court hearing is, something the court should take into account. I will indicate Ms. Misick reported for probation officer. That's how she came to be under arrest. She advises she has been reporting. I understand there's some disagreement, and we're going to have a hearing about the date she reported, whether she was in substantial compliance or not. But she advises she's been regularly reporting. She has, a lot of financial difficulties. She's working on a remodel job where she won't get paid until the end of the job, so she's very low on funds right now, and she'd ask for a $500 bond. Thank you.
All right, the court will set bond in the amount of $500 cash or surety. I think that's a reasonable amount of bond, given the nature of the allegation here. The court will include all standard terms and conditions of bond, along with all conditions of probation. And then again, Ms. Misick, the court's going to set this for a hearing. You need to make sure that you stay in touch with your probation agent and that you contact the court so that you know what that date and time of that hearing is, okay?
Yes, sir.
Just as she's having housing issues, the current address I have for her is Boardman Road, Southwest and South Boardman. Does she still want notices sent there, or does she want them sent somewhere else?
No, I need it sent to my mom's address, which I'm not 100% sure on what it is right now, but I thought you guys already had that address because that's where my probation in Travers sends everything.
Miss Misick, is that the address in Fife Lake?
Yes.
10874 Vans Lane.
Yes.
Okay, so I have 10874 Vans, VANS Lane, Fife Lake, Michigan, 49633.
Thank you. She did not update her address with me.
And that's the same address on the summons. Okay, November 5th. All right, thank you.
Thank you. All right, Ms. Misick, that's all for this hearing today.
Okay, thank you.
Is Mr. Trombley present?
And see Mr. Trombley, we do have Mr. Juliet here from Sheboygan County, and he's got a hearing at 1 o'clock. The roads aren't great today.
Yeah, well, we're behind on everything right now. So.
All right.
Your Honor, Mr. Trombley had been in Roscommon County Jail as of January 30th. I don't know if he posted bond on a new charge or not.
This was set for probation violation hearing today.
Yes.
There was a writ for today.
I'm not sure what we'll be able to do on that because they charged him, right?
He did get charged, so.
Yeah, so I don't know that we're gonna be able to do anything on that today.
Do we want to move that hearing out?
I think it makes sense. So the allegations that form the basis of the PV are now criminal charges in Roscommon County that are pending.
Yeah, I think an adjournment would be appropriate for that, Your Honor.
Okay. If we set this out 60 days, that's not reasonable.
I think so. Then we can see where the underlying charge is at that point.
I agree.
Okay, so we'll set Mr. Trombley's matter for another hearing in about 60 days.
Maybe Mr. McGrath, I think.
Sir, are you Xavier McGrath?
Yes, Your Honor.
All right, let's go on the record as People versus McGrath. This is file number 255423. The record should reflect Mr. McGrath is present today by video from Crawford County Jail. This is an arraignment on some alleged probation violations.
I did, Your Honor, and obviously I'm concerned this could form new criminal allegations. So at this point, Mr. McGrath is going to stand due to the charges.
Okay, the court will enter a not guilty plea, Mr. McGrath, on your behalf with regard to the alleged probation violations. And then the court will set this for a hearing. Mr. Haven, do you have any recommendations regarding bond pending that hearing?
Yes, Your Honor, these allegations are almost a carbon copy of what his underlying offenses that he's on probation for. And they're pretty serious charges. So I think a fairly high bond would be appropriate.
Mr. Thompson?
Thank you, Your Honor. I did speak with Mr. McGrath. He is requesting court-appointed counsel, and I will be appointed. He does report that he has family. He's got a mother who he lives with, who's local to Crawford County. He has a good job at Cooper Standard that he was able to return to. So he has strong ties to the community and strong incentives to appear to court on this case. So I'd ask the court to set a reasonable cash bond, perhaps a $5,000 bond. Thank you.
Your Honor, is there any way that I could speak on that at all?
Yes, absolutely.
Your Honor, then I would just like to advocate that Mr. Thompson was just saying, that I have every intention on being present for everything that I have to do for throughout this. And these are just allegations at this point. I would just think that I would really like the opportunity to continue my life and what I do have going on while I have to go through this process, Your Honor. A 5,000 bond, that's something that I've worked at, I would be able to do, and that would just allow me to continue the good things I do have going for in my life, like my good job that I have. And I've been working a long time at my sobriety. I just had a slip up after 130 some days sober, Your Honor. I do have a good head on my shoulders. This probation originally was for drinking violation. And I came in to report to see my probation officer 100% and did everything I have to do, and I'm going to continue to do everything I have to do. I would just like the opportunity to be able to continue the good things that I do have going for my life while I go through this process, Your Honor. And with a high bond like that, I don't have a lot of money saved up, and I'm not going to be able to post it.
All right, well, the court, looking at the allegations here, which do involve allegations of assaultive conduct, and I would think are likely to result in some additional charges over and above charges for violating your probation. Based on that, the court does have some public safety concerns, so I do think a $5,000 cash assurity bond is an appropriate bond, both to ensure your appearance at future hearings as well as for purposes of public safety. The court is also going to impose all conditions of probation as the conditions of bond, along with all standard conditions. The court is also going to impose no contact provisions with the named victim in this case as part of the bond as well. And then the court will direct this to be set for hearing within 14 days. Mr. McGrath, if you're not able to postpone, you do have the right to have a hearing within 14 days. So the court will set it for a hearing at that time before Judge Hunter, and we'll go forward from there. So make sure that you stay in touch with your attorney, Mr. McGrath, and you'll be notified of the date and time of that hearing.
Your Honor, there's no way that I could please get a 10% on that so I could continue